Welcome to Divorced from Reality with Johnny Bardine.
Welcome to Divorced from Reality with Johnny Bardine. Johnny is a dedicated attorney who has been serving the Tampa Bay community for over a decade with the mission to help individuals and families through their most challenging times. Johnny provides compassionate, fierce advocacy in divorce, foreclosure, personal injury, and probate matters. I'm Evan Mack, and today we're talking about how and when you can modify child support, custody, or alimony in Florida. Johnny, sir, welcome.
Hey, Evan, how you doing today?
That's a hell of a beard you got there, Johnny.
Doing my best. I trimmed it last week. It was getting a little bit Grizzly Adams-ish. So.
'Tis the season, though, but you're right.
It's freezing here this morning in Florida.
We're going to be talking about how to modify this child support, custody, or alimony in Florida, but let's start us off, Johnny. Can you explain what kinds of situations qualify for that legal modification under Florida law?
Yeah, so what we're talking about here is a modification of an existing final judgment. So after the divorce is done or the paternity process is finished, you've got a final judgment, and then there's some change that happens after that you often can't predict. So that's what we're talking about. We're talking about modifying a final judgment with regard to child support, sometimes parenting time or alimony. And the key word, and what we're going to keep coming back to, is what's called a substantial change in circumstances.
People often assume any major life change means an automatic adjustment. How do you Florida courts, kind of decide whether a change is substantial enough to reopen the case?
Yeah, so that's not accurate. So the changes or modifying based on any bump in life is not going to do it here in Florida. What you need to show is substantial change in circumstances, which needs to be a substantial and material change that is involuntary and ongoing. 2 years ago, the Florida state legislature changed the law to remove the word unanticipated. So the change no longer has to be an unanticipated change. And mostly, I think that was to correct for children getting older and the changing needs of children as they get older, because that is going to be an anticipated change.
But when it comes to child support, what are the main reasons parents can come back to the court to request a change? What kind of documentation can help prove their case?
Well, there are some common reasons for child support modification. Notably, if a parent's income drops significantly, they get a job loss or a layoff or disability or reduced hours, or conversely, if a parent's income increases significantly, a promotion, a new higher paying job, and thus the support may need to change. Along with that is an increase or decrease in the child's needs, or if a special needs emerge as the child gets older. And the standard for modifying child support is whether the child support with the new changed income of the parents will change the child support $50 or 15%, whichever is greater. And obviously, in all these cases, in every case, if Florida family law case, the parents need to submit initially some financial affidavit, which details their income expenses each month, and that forms the basis of child support. And along with that is the documentation that substantiates that. So recent pay stubs or employment letters or expense records related to daycare, things like that. Those are the documentation that you're going to need to be successful in modifying child support in Florida.
But if both parents agree on a new time sharing or support plan, can they file jointly for this modification, or does it kind of need some kind of formal hearing still?
Yes, and to the extent that it's possible, it's recommended. So in these cases, and this is what I tell clients all the time, they get decided in two ways. Either you guys just agree or the court will decide.
Yeah.
So if the parties can agree to something, they can execute a joint stipulation for that change. But then it still needs to be approved and ratified by the judge, and the judge has to sign off on it as being in the children's best interest. So the answer is yes. That can save a lot of time and money and mental health expenditure. But at the end of the day, if the parties can agree, they should, and then the court will often ratify that agreement if it's fair.
So let's kind of switch gears to the alimony. What are some of the common scenarios where a judge will consider increasing, decreasing, or maybe just ending the alimony altogether?
Again, the Florida state legislature changed the statute a couple years ago that I think has improved the way that we can modify alimony in Florida,
Mhm.
and one of them is that now if a party is retired, that could be a basis for terminating or ending the um, the alimony obligation. The court will still look at that the payor spouse's assets and living expenses before doing that. But retirement is a big one. Decreasing a decrease in the payer's income, an increase in the recipient's income, uh, and whether there's been some other life changing circumstance like health or disability.
For custody or time sharing, what does the process look like when a parent wants to modify an existing parenting plan? How long can that take? What's the typical outcome in some of the things that you've seen?
The time modification of child support, or I'm sorry, time sharing could take is variable. I mean, it depends on the disposition of the parties or how agreeable or litigious the thing could be, and the calendar and process of the court, which can sometimes be a bit tedious to work through and beyond my control. But the process is that the party who wants to the modification files what's called a supplemental petition to modify the final judgment. And in that petition, they set forth the reasons and state with particularity the substantial change in circumstances. There's a second prong. So substantial change is the first one. The second one is that the change has to be in the best interest of the children. So they file that petition, serve it upon the other party. The other party, after service, has 20 days to respond, and then the first step after that answer is filed is that the parties get about the business of updating their financial information. So they submit their financial affidavit and the mandatory disclosure, which are the substantiating documents that follow that. And that can be a tedious and difficult process, because that's important to get right, because that's going to form the basis of the new child support order, and it's also a court requirement under the statute. After that, the parties generally are going to be ordered to attend mediation to try to resolve it. Um, and often they do, because these cases can be time intensive and expensive to get through. So often they resolve at mediation. If they do not, then we generally get it pointed to uh, trial, so the court can make the final decision.
Mm. Johnny, in your experiences, are there mistakes you see people make when they try to handle these modifications on their own without counsel, things that end up slowing the process or maybe costing them more down the road?
Yeah. So, if you'd never studied Spanish and you went to Spain, you'd have a hard time communicating and
Hmm,
getting around and getting what you want. And the reason
hmm,
is you don't speak Spanish. And
hmm,
so in this process, it's a different language and a different set and a different culture and a different process, and things that are unfamiliar to people who don't have lawyers. So even though you think you're right, or you're a smart person, or you want to go forward on yourself, it's a hard one to do on your own. Um,
wow.
so one of the issues, that assuming that any change will be enough, and we just said earlier that it requires quite a substantial material change to do it, and so we need to analyze the changes that meet the legal standard, uh, and then we need to prove it. So we need to gather up all the proper evidence and all the documentation that we need. We need to fill out the required forms and follow the process. Make sure that every T is crossed and I is dotted. That's difficult for someone who's not represented, and and then we ought not assume that a sort of tangential agreement is enough. You still need to go about codifying it in the proper documents and then getting the judge to sign off on it. And then, time is important too. So sometimes you think that a substantial change is coming, but you may not be there yet. So I think early on in the process, it's important to at least have a consult with a lawyer, so you can strategize, know your rights, and understand a bit about the process, so that you can get together the information you need and then execute it at the right time.
How do you help clients approach these changes in a way that protects the children's stability, keeps communication between parents as healthy as it can, during these kind of tough times?
Well, in each and every family law case, I don't think there's anything more paramount than focusing on what's best for the children.
Yep.
And when changes are proposed, I try to help clients ask, will this help my child's welfare, schooling, friendships, activities, stability?
Hmm.
And when both parents see that as the compass, then the discussion becomes more constructive and a little more focused on meeting those goals. And
Hmm.
then I think strategically, what we do in our practice as we move through these processes, that I try to do a carrot and stick process. So I'm
Hmm.
always trying to resolve it, right? Because it's always better for the parties to agree than a stranger in a black robe to decide who
Right.
doesn't know you. And so I am always encouraging conciliation that way, but also um, exerting some leverage by filing the appropriate things in the court and keeping things moving in the judicial processes so that everyone kind of understands their potential exposure or risk in the process.
So, Johnny, for anyone listening who is wondering whether their situation qualifies for modification, what's the smartest first step to take before filing anything with the court, in your opinion?
We touched on this a little bit. So you have to evaluate your facts, and you have to start by writing down, a pro con list is a great idea. So write down everything that you think helps your case, and then be
Mhm.
very honest and transparent with yourself about what might not help your case. Uh, you need to understand what the court has already ordered. So you need to look at the current order and evaluate that so that you know exactly where and how you can modify that. Um, you need to understand the legal standard. As we talked about, it's a high and extraordinary standard, the substantial change in circumstances. So we need to look at whether the changes are going to meet that burden. Gather the documentation you need, because this is going to be a document intensive and evidence intensive process. And then I think most importantly, you need to be transparent with the other parent. So I don't think there's much benefit to the element of surprise, but I think you need to be, but because you have to co-parent with that person before uh, the final judgment, after it, and pending any modification of it. So that's going to be your co-parenting partner. So communicating with them and talking to them about your uh, potential plan, I think, is really important to do.
Johnny, thanks for your time, sir.
Appreciate it, man.
All righty. And thank you all for listening to Divorce from Reality with Johnny Bardine. For more information or to connect with Johnny personally, visit bardinelawfirm.com. Don't forget to like, subscribe, and leave a review wherever you listen to your podcast. Share this with someone else who might find it helpful. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.